It definitely didn't address the standards of care. It did leave that to the medical community. It said, you know, Congress was not going to address every treatment for every condition. But it said you do what is needed to assure non-deterioration. So I guess the question here is, do you concede that with respect to certain medical conditions, an abortion is the standard of care?
No, because the standard of care I should say, in Idaho, there's a life-saving exception for certain abortions, and that is the standard of care. And the standard of care is necessarily set and determined by state.
Well, I think you have to concede that with respect to certain medical conditions, abortion is the standard of care because your own statute, as interpreted by your own courts, acknowledges that when a condition gets bad enough such that the woman's life is in peril, then the doctors are supposed to give abortions. And the reason that that's true is that with respect to certain rare but extremely obviously important conditions and circumstances, abortion is the accepted medical standard of care. Isn't that right?
Yes, and that was my point, that there is a life-saving exception under Idaho law. Now, the question here is...
Now the question is it also the accepted standard of care when, rather than the woman's life being in peril, the woman's health is in peril? So let's take, all of these cases are rare, but within these rare cases, there's a significant number where the woman is, her life is not in peril, but she's going to lose her reproductive organs. She's going to lose the ability to have children in the future, unless an abortion takes place. Now, that's the category of cases in which EMTALA says, my gosh, of course the abortion is necessary to assure that no material deterioration occurs. And yet Idaho says, sorry, no abortion here. And the result is that these patients are now helicoptered out of state.
Yeah. Your Honor, the hypothetical you raise is a very difficult situation. And these situations, I mean, nobody's arguing that they don't raise tough medical questions that implicate deeply theological and moral questions. And Idaho, like 22 other states, and even Congress and EMTALA, recognizes that there are two patients to consider in those circumstances. And the two-patient scenario is tough when you have these competing interests.
You know, that would be a good response if federal law did not take a position on what you characterize as a tough question. But federal law does take a position on that question. It says that you don't have to wait until the person is on the verge of death. If the woman is going to lose her reproductive organs, that's enough to trigger this duty on the part of the hospital to stabilize the patient. And the way to stabilize patients in these circumstances, all doctors agree.
And Idaho law does not require that doctors wait until a patient is on the verge of death. There is no imminency requirement. There is no medical certainty requirement.